Welcome to the Disability Granted channel. You suffer a severe disabling condition. You've got no job, little income if any. You've got inadequate health care. You've got bills, more bills, and maybe less friends. You need to apply for a Social Security disability. You need both financial and medical benefits. But experts publish these discouraging numbers. You see them on the internet, you see them on websites. You may even hear people repeat these numbers. The experts, the authorities, will tell you that only 30% of Social Security applications are approved. Only 30%. That's rather discouraging. Is it true? No. No, it's not true. You can only get the figure that low if you include technical denials, which have nothing to do with disabling conditions. In Social Security studies for disability medical determinations, technical denials are particularly excluded. Social Security doesn't use them in making any such determination. Social Security excludes them because technical denials generally lack evaluation of any medical evidence. So, what are technical denials? Well, they're not disability determinations. Disability determinations are made by the Disability Determination Services. That's where the disability examiners are. Social Security tells us that the field office is responsible for verifying non-medical eligibility requirements. The field office is responsible for verifying if the application meets required technical requirements. If it does, if the application meets those requirements, it sends the application to DDS for evaluation of disability. And DDS is responsible for developing medical evidence, making the initial determination on whether or not a claimant is disabled or blind under law. So why do some authorities measure your chance of being granted Social Security disability by including every case which was technically disapproved without a disability determination? Something's not right. Social Security actually shows us how many applications for disability were medically approved. It's closer to 45%. So what are the common technical denials used to dilute your success rate to 30%? Let's look at common technical denials which have been published by the administration. Social Security says it will technically deny any application, either SSI or SSDI, for disability for the following 9 technical reasons. Number 1, your application will be technically denied if you're not an American citizen or a resident legal alien. Does that have anything to do with determining disability? No. That has nothing to do with the applicant's disability, if any. 2, your claim will be technically denied if your application has already been made and denied. And this is something you need to realize. Too many people, if they get notice of disapproved claim, they appeal by just filing a new application. You do not appeal by filing a new application. Matter of fact, in the notice of disapproved claim, they tell you how to appeal. They tell you to file a request for reconsideration, and they even provide that document to you with instructions. And it's not like it's a hard document to complete. But you do not appeal a denied application by filing a new application. You do not appeal an unfavorable reconsideration by filing a new application. You don't appeal an unfavorable determination by an administrative law judge by filing a new application. You don't do it because it will be technically denied. At this point, we're just talking about applications. We're talking about technical denials of applications because we're seeing all these figures that are very discouraging to disabled people. We're seeing figures that only 30% of disability applications are approved. There's no disclaimer to it. There's nothing. They just put it out there like that. They don't tell you that applications are approved at a 45% rate when they have a medical determination. It's not a technical determination based on something completely not involved with disability. Your application for Social Security disability, whether SSI or SSDI, will be technically denied if you don't cooperate with your disability examiner. If you don't cooperate with your disability examiner, he or she cannot complete your claim. You have to cooperate. Don't get defiant. Don't let people encourage you to be defiant. Don't let people tell you that the disability examiner is out to get you. Just cooperate. If the disability examiner calls you, call him back. If the disability examiner asks you or sets up a consultative examination for you, attend it. If the disability examiner asks you to complete a form, and you're going to see that in here too about completing forms, do so. Look, the people that get approved by a disability examiner. You want to be one of them. Number 4, your application for Social Security disability will be technically denied if your claim can't get processed because your whereabouts are unknown. How can a disability examiner contact you to get more information, contact you to get you to complete forms if they're required? How can they even get a status of you if they don't know where you are? If they don't have a phone number? At least give them contact information of a family member or a close friend so that they can get to you through your contact. Don't let it be whereabouts unknown. Don't be the mystery person. You can't contact me. Don't do that. Number 5, your application for Social Security disability will be technically denied if you don't attend your scheduled consultative examination. And too often I see sources, even authorities, warning against the consultative examinations, that doctors are out to get you, that they're hired by Social Security for one purpose, and that's to prove that you're not disabled. That's ridiculous. This channel is producing a video on consultative examinations. You may want to watch that. Go to your consultative examination. Don't go with the chip on your shoulder. Don't go thinking everybody's out to get you, unless your disability is paranoia. If you miss your consultative examination, again, the disability examiner can't complete your claim. And if the examiner can't complete your claim, has to deny it. You have to cooperate with your disability examiner too. If you have any questions about it, ask the disability examiner. Why do you need this? You may ask them whether your own private physician can do the consultative examination. And if your doctor is knows how to do consultative examinations. If your doctor is qualified to do them, Social Security might well say, yes, we just need it. We need it. Get it from your doctor. But if your doctor is not qualified, then they likely will have to send you to a doctor that is. And here's one which we touched on before. Your application for Social Security disability will be technically denied if you don't complete forms required by your disability examiner. These are forms which you are required to do. It's not like the disability examiner just said, oh, I've got a form. I made up a form. I want you to. It's not that. These are forms which people applying for disability must complete. Even the application, you have to complete it. Many people don't complete their application. They leave things blank. You have to complete the application. If the disability examiner asks you to do so, do it. And there are other forms that you provide. And these forms, you need to do these forms to prove your disability. The burden of proving your disability is on you. Until you prove you're disabled, as a matter of law, you're not. So at the application level, the forms include your application, as I mentioned, an adult disability report, an adult function report, maybe a work history report or work function report. You also need to sign an authorization to disclose information. That is a form that requires very little other than signing it. Number 7, your application for Social Security disability will be technically denied if you don't authorize the Social Security Administration permission to contact financial institutions and request financial records. That's required. And think about it. This is Social Security. If you're working and if you're earning wages, likely there are withholdings from those wages, which include Social Security. So if you're working and earning wages, the chances are they're going to have access to those records at the very least. But they want access. They're entitled to access. If you need to prove, and you do need to prove that you're disabled, provide them access to those records. Sooner or later you will, because if you're approved, you're going to have to provide your bank routing number and your account number in which your benefits will be deposited. Your application may be denied upon your death after the field office transfers your disability claim to the Disability Determination Services. It may not be denied. Your estate may be allowed to continue it. Abatement may be appropriate under certain conditions. Abatements where the claim just simply stops. Now, let's look at SSDI applications. We have SSDI, which requires work credits. We have SSI, which basically requires poverty. They're different programs, but they're both disability programs, which do have some similarities. They both have the same definition of disability. They both have the same 5-step evaluation process for disability. Number 1, we're talking about SSDI only. Your Social Security disability application for SSDI may be technically denied if you're engaged in what they call substantial gainful activity. Disability thresholds in 2023 include substantial gainful activity of $1,470 for disabled applicants and $2,460 for blind. Number 2, in SSDI cases, your application will be technically denied if you lack sufficient work credits. In SSDI, you have to have work credits. SSDI is an entitlement program, and you're entitled if you have contributed to the fund for SSDI payments, and that would be through payroll deductions from your work. SSDI is funded by payroll deductions. If you're 31 years of age or older, you must have at least 20 work credits in the 10-year period immediately preceding your onset of disability, the date on which you became disabled. There are different requirements for younger age groups. If you do not have sufficient credits from your work history, you may possibly qualify. This is important. If you don't have sufficient work credits from your own work history, you may possibly qualify by using the work credits of another, as allowed by Social Security, as allowed by law. There are certain situations and instances in which you can access the work credits of another. That may be a parent, maybe a step-parent, maybe an adoptive parent, maybe a grandparent. It could be a spouse or an ex-spouse that hates you, and you don't need that person's permission. And if you're allowed to use their Social Security number, it will not affect their benefits in any way. If you can't access another person's work credits, if you can't use another person's work credits and you don't have enough, you may not qualify for SSDI, but you may qualify for SSI disability, which has no work credits. It requires no work credits. Number 3, in SSDI cases, your application will be technically denied when you allege an onset date that is after the date you were last insured. It's an entitlement program. It's Social Security disability insurance. So we're talking about insurance, which is an entitlement program. You must have sufficient work credits to be granted SSDI. And those work credits, if you have the right amount, if you have sufficient work credits, you're covered by SSDI. And as we mentioned before, you have to have at least 20 work credits in the previous 10 years if you're age 31 or older. And at younger ages, there are different requirements, but there are work credit requirements. If you allege an onset date when you don't have sufficient work credits to be insured, and you allege that onset date in your application, you're going to be denied technically, because there's no way Social Security could grant you SSDI if you allege that you weren't insured at the time your disability began. So if there's any question as to your onset date, give yourself the benefit of the doubt. Don't self-deny your claim. Social Security may not deny it. They may look at it differently than you do. They may think that, in their opinion, that you qualify. And that doesn't apply to SSI claims because they have no requirement for work credits. SSI is not an entitlement program. It's not insurance. It's welfare. Number 4, this is the last technical denial specifically for SSDI. Number 4, your application for SSDI may be technically denied after the death of a number holder whose work credits you're using. If you don't have enough work credits, you may need the work credits of another. If that's authorized by Social Security, if that's allowed by Social Security, then you can proceed so long as that number holder, the holder of the Social Security number you're using is alive. But if that number holder perishes, then your application is going to be denied unless you have sufficient work credits. You may have sufficient work credits and still use the work credits of another to increase your benefit. If you don't have sufficient work credits on your own, you may have to seek another number holder to qualify for SSDI. But if you have sufficient work credits and still use the work credits of another to increase your benefit. If you don't have sufficient work credits on your own, you may have to seek another number holder to qualify for SSDI. But if you don't have work credits, if you're using the work credits of another and that person dies, your application is going to be denied because of lack of work credits. And that's important for SSDI. You have to be insured, and to be insured, you have to have sufficient work credits. Now, let's talk about SSI. Your application for supplemental security income, that's SSI, may be technically denied for the following 5 reasons. Number 1, if you apply for supplemental security income, your application will be technically denied if you've been absent from the country for 1 month or 30 consecutive days. Number 2, if you apply for supplemental security income, your application will be technically denied if you're an alien who is subject to an active warrant for deportation or removal. Deportation is a term that's no longer used. Deportation and removal are the same thing. They changed the terminology about 20 years ago. Have you noticed one thing? Do any of these technical denials have anything to do with whether you suffer a disability? No. None of these technical denials have anything to do with any kind of questions as to whether or not you're disabled. If you apply for supplemental security income, your application will be technically denied if you're not a U.S. citizen or national or a non-citizen in one of certain alien classifications granted by the Department of Homeland Security. Your application for Supplemental Security Income Disability, SSI, will be denied if you are confined to an institution such as a hospital or prison at the government's expense. Number 5, your SSI disability application may be technically denied because you have too many resources. The resource limit for SSI is $2,000 for an individual and $3,000 for couples in 2023. If you think this video would help other disabled people, please share, like, and subscribe so that they can see it. Thank you for watching the Disability Granted channel, and good luck.